We move on to section 26, which is our clause 11 here. Amendment of section 26 of the Act. Section 26 reads, devolution of residential holdings. Subsection 1 reads, the residential holding normally occupied by a person dying intestate prior to his or her death as his or her principal residence, or owned by him or her as a principal residential holding, including the house chattels therein, shall be held by his or her personal representative upon trust for his or her legal heir, subject to the rights of occupation and terms and conditions set out in the second schedule of the Act. So you see, under this section currently as it reads, the house, the one that would refer to as a principal residential holding or matrimonial property while you're still alive, upon death of one of the spouses, it was to be held in trust by the personal representative. That is either the administrator or the executor of the will, in trust for who? For the legal heir, and it was not even for the spouse. So that really eliminates protection for the family, for the surviving spouse and for the children, and leaves them open to abuse of this power by the legal heir. The legal heir could decide to deal with the property as he chooses, because anyway it's being held in trust for them. So now we have amended this to read, we are substituting this clause 1 to read, the principal residential holding and any other residential holding shall devolve to the surviving spouse and lineal descendants of the deceased. So automatically this property passes on to the surviving spouse and lineal descendants. And lineal descendants for us refers to a child, both male and female. Section 27 of the Principal Act, which is our clause 12 here, substitution of section 27 of the Principal Act. Section 27 of the Principal Act provides for distribution of property on the death of an intestate. An intestate is a person who dies without leaving behind a valid will. Not just any will, but a valid, legally valid will. So this section equally was declared discriminatory in that case of law Uganda, and it's what created the implementation gap in the Administrator General's office and in courts of law, because whereas section 27 as it is now has percentages it gives to a spouse, after being declared unconstitutional, these percentages were dealt away with. So now judges, it was up to the discretion of a judge to decide what percentage should I give to the widow, should I give to the dependent relatives, should I give to the children. So it was inconsistency, and that inconsistency, anytime there is inconsistency, there is room for abuse. So we decided, basing also on section, article actually, 31 of the Constitution that reads, man and woman are equal at the beginning, during, and at the devolution of marriage. So that provides for even you're equal in how you distribute your property. So right now it's reading, subjects to section 29 and 30 of the Act, the estate of an intestate, except his or her residential holding or other residential holding. Like I mentioned, the residential holding are not subject to this distribution, shall be divided among the following classes in the following manner. So this is for the rest of the estate, aside from the principal residential holding and other residential holding. A, where the intestate is survived by a spouse, a lineal descendant, and a dependent relative. That could be your mother, could be your father, it could be your uncle, anyone who's solely dependent on you. for survival, for sustenance, that is who qualifies as a dependent relative. So in the case that an intestate is survived by a spouse, a child, that is a lineal descendant, and a dependent relative, the spouse shall receive 50% of the estate. The dependent relative shall receive 9%. The lineal descendants, who are our children, shall receive 41% of the whole property of the intestate. But where the intestate leaves no surviving spouse or dependent relative under paragraph A. So that is, paragraph A is basically providing for a scenario where someone has, as is the case with most families anyway, you have a spouse, you have a child, and you have dependents who are depending solely on you for their survival. So in that case, the spouse will get 50%, child will get 41%, child or children get 41%, and the dependent relatives get 9%. So this is the second scenario, which is B, where the spouse leaves no surviving, where the intestate, leaves no surviving spouse or dependent relative. So you leave only a child. Under I or 2, this paragraph is capable of taking a portion of his or her estate. That portion shall entirely go to the lineal descendants. So where you leave only children, there are no dependents, there are no spouses, 100% of that estate should go to your child. Then we have scenario B, where the intestate is survived by a spouse, a dependent relative, but no lineal descendant, no children. The spouse shall receive 80% of the estate. The dependent relative shall receive 20% of the whole of the estate. So this is for scenarios where there are no children. So it's also premised on the fact that together with your spouse, you worked hard for this property together. So it is only fair, on equitable grounds, that they are entitled to the largest proportion where there are no children. Then the third scenario is where the intestate is survived by a spouse or dependent relative, but no lineal descendant. Where the intestate is survived by a spouse or a dependent relative, but there is no lineal descendant, the spouse or dependent relative, as the case may be, shall receive 100% of the whole of the property of the estate. So this is for a scenario where you either have just a spouse or you have a dependent relative. You've died and you've only left your mother, elderly woman who you're taking care of. That person is entitled, where there is no spouse and there is no child in question, to 100% of your entire property. And your dependent relatives could be more than one. In that case, they are entitled to 100%. D, where the intestate leaves no person surviving, him or her. I don't know if that scenario is possible, but in the event that you have no one, you leave no one surviving you, capable of taking a proportion of his or her property under paragraphs A, B, or C, the estate shall be divided equally between those relatives in the nearest degree of kinship to the estate. So your relatives shall have, your property will be divided equally in equal proportions against those nearest in degree of kinship to you. E, where the intestate leaves no person surviving him or her, capable of taking a proportion of his or her property under paragraphs A, B, C, or D, the whole of their property shall belong to the legal heir. 2, a person may apply to court for an order that he or she is entitled to the deceased estate or occupation of the residential holding, or occupation of a residential holding occupied by the deceased. There may be people who are not provided for in our distribution as we have it right now, our distribution scheme, let me call it scheme, and yet they provided for I mean, they contributed to this estate in a significant manner. So these people may apply to court for issues of intestacy and say, and argue their case and say, I contributed significantly to this estate, so I deserve to be given a portion of this estate. And this is also where they are not, as I earlier mentioned, they are neither a lineal descendant, they are not a dependent relative, they are not a spouse, they are not nearest in degree of kinship to you. So we have such scenarios where perhaps you're in a relationship that is not legal, not recognized under the law. You're protected because you have the leeway to go to court and argue your case and say, I am entitled to a portion of that estate. So that is what clause 2 meant to cure, not to completely leave out people who under equitable grounds would be entitled to portions of these estates. Then 3, in making the order under subsection 3, court shall have due regard to 1, the nature of the relationship between the deceased and the applicant, the contribution made by the applicant to the deceased's estate, and 3, any other relevant evidence that the court deems necessary. So these are the considerations that court will have when you make your application under 2. So I think there's a mistake there. It's supposed to be in making the order under subsection 2, not subsection 3, as it currently reads.